Good morning, Mr. Doyle.
Good morning. May it please the Court, my name is James Doyle. I represent the appellant, Paul Gunter, in this case. Gunter was tried and convicted on an invalid theory of felony murder. There was no objection raised at trial to this theory of felony murder. The issue was not briefed in the initial brief by his appellate counsel. On direct appeal, no motion for a new trial was filed in concert with the direct appeal. This Court, sua sponte, raised the question of the validity of the felony murder rule on which Gunter's conviction depended. Again, after that had been raised, counsel did not respond in a way that addressed the new theory which this Court ultimately developed and applied to Gunter's case.
Mr. Doyle, let me ask you, if appellate counsel in the original Gunter case, the original appeal, had filed a motion for reconsideration, what would it have sounded like?
A motion for reconsideration was filed in letter form addressing in broad standards a protest essentially against the substitution of theories which had not been raised. However, it did not join issue with the question of the new factual predicate which the new theory demanded. The difference between this case and the Kilburn case, upon which the Commonwealth and the motions judge relied, is that in Kilburn, as Justice Cowan noted, you did substitute one assault for another as a felony murder predicate. However, in the Kilburn case, it was the same victim, it was the same explicit plan, and the substitution raised no questions about the scope and purpose of the venture and the relationship between the scope and purpose of the venture and the homicidal assault, which ultimately had to be connected and related to the first assault and the dwelling which underlay it.
In here, the judge, you're saying, I take it, that the judge should have, if this theory were played out at the trial, the judge should have instructed the jury that there had to have been the Commonwealth had to have proved beyond a reasonable doubt that the underlying felony was armed assault with intent to, just armed assault in the dwelling of one of those other people.
Yeah, other victims.
Yes, and that counsel, and this case also has a genesis in ineffective assistance of trial counsel, should have argued to the jury that conviction ultimately would depend on their finding beyond a reasonable doubt that Selby, the shooter, was acting in furtherance of the venture which the first assault, the new assault, was motivated by.
Now, in Gunter, did the judge ever instruct the jury on the question of either as the predicate felony or as any other indictments, as the subject of any other indictments, that the other three people were, the Commonwealth had to prove that the other three people were victims of armed assault?
No. The instructions in Gunter, the entire Gunter trial proceeds exactly as if the invalidated felony murder premise was a valid felony murder premise and the only premise in the trial. On a verbal level, the instructions invite the jurors to concentrate on the assaults charged in the indictments.
Yeah.
The indictment at that trial was the assault on Jack Berry, and Jack Berry was the homicide decedent. At no point does the judge say, don't consider these other matters. But for lay jurors hearing these instructions, it's very clear that they're directed to concentrate on Berry, the assault on Berry, and to treat other things as a distraction.
Were there indictments for the other victims?
No. In this court's opinion in that case, this court suggests that going forward, the prosecution seek jury questions and verdict forms on that issue, and that's one of the reasons that this case is, I believe, a freakish one, which is unlikely to arise again.
Your point is just that the fact that the court in the direct appeal said under 33, well, there's sufficient evidence of the assaults on these other people doesn't answer the question whether the jury should have focused on not whether it's sufficient, but whether they would find beyond a reasonable doubt that one of those assaults was the predicate to the felony.
Well, we go a little further than that and say that the constitutional issue is ultimately whether the jury had the power to reject that proposition. It's true that the jury might have agreed with that proposition, but it's also clear that this trial jury had no opportunity to reject that proposition. It was never presented to them in a way that they could act on it. It's among many hypothetical findings that the jury could have made, but what's, I think, constitutionally important, and what amounts to a jurisdictional defect in this conviction, is that the jury never had the opportunity to say no to this proposition. No jury has. In fact, trial counsel never noticed it, never presented it to them. None of the appellate counsel presented that issue. When this matter was on direct appeal, the Commonwealth's position was not that the invalidation of the original felony murder theory would result in a first-degree murder along the lines that this court arrived at.
They asked for second degree.
They asked for second-degree murder premised on the weapons charge. Now, we don't accept that either, but it is clear that the Commonwealth did not see this then. No jury has ever seen it. No jury has ever had the opportunity to accept it or to reject it. And so we believe that this is a case of a very, although it looks, because of the choices made by counsel and the approaches of trial counsel and appellate counsel, very much on the surface like a Kilburn case, where it's almost a matter of judicial housekeeping to say we're going to substitute one assault for another here and still have a felony murder predicate. On the facts of this case, because the substitution of the assaults involves a further fact that Selby was acting in the same purpose as the bystander assaults when he committed the homicidal assault, then this raises a new jury question, which under the Declaration of Rights we say is structural, cannot be harmless. Under the federal Constitution, the Supreme Court says could be harmless, but we say in this case it was not.
Mr. Doyle, could I ask you a question? I just didn't have a chance to go back and look at this. The counsel on direct appellate review was the same as trial counsel, correct?
I'm sorry, Your Honor.
Counsel on the direct appeal, which is the appeal
No,
here.
there was different counsel on the direct appeal. However, that counsel also did not raise the question of the invalidity
And
of the
was
felony
it that
murder.
counsel who filed the petition for a rehearing?
Yes.
Okay.
Let me try to pull a few things apart for a second, because I want to make sure I understand your argument. You were, at least in your motion for a new trial, and I thought on appeal, the thrust of your argument on appeal was ineffective assistance of counsel. And now I'm hearing you to say that it was really sort of a structural error.
I believe we've always said both, Your Honor.
Okay.
Now, remember that there was no new trial motion filed during the direct appeal process. There was no new trial motion filed until after this court had arrived at the new theory, which is now the foundation for the conviction and judgment.
Okay.
Now, assume you are correct substantively. The gatekeeper has already denied it.
Yes.
How do we consider it without changing our rule that the gatekeeper is final?
Well, this is not a simple case, putting aside the constitutional issues for a moment. The gatekeeper's jurisdiction, the gatekeeper's role, depends on there being a first-degree murder conviction for the gatekeeper to act on, and that in turn depends on a jury finding of the degree of murder under 265 Section 1. And so that this court would have to wrestle with the question of whether this jurisdictional issue affects the gatekeeper's role in this process at all. We also believe that a jurisdictional issue is a jurisdictional issue, and certainly that Section 211.3 gives this court powers to act in cases which, like this one, I believe, have freakish procedural histories.
Could we also consider your motion for new trial as also including a request for reconsideration?
Yes. This court, I believe, under 211.3 and the all-rich jurisdiction in 211.3, I believe 211.3 is written for situations such as this, where you have anomalous situations created by the interactions of statutes, and this court has the power to do justice in these situations. I don't want to seem as though I'm critical about this. The way these questions were framed by counsel, this case looks very much like the Kilburn case. But in the end, this comes down to a question of whether a jury was ever presented with an indispensable factual proposition that the jury has to have the right to accept or reject. And that's a key matter under the federal Constitution, but we argue even more so under the Declaration of Rights. The decision by the British Crown to move common law trials to the Vice Admiralty courts and dispense with lay juries was one of the core motivations for the revolution in Massachusetts. And that's what happened here. There's no way to simply substitute, as there was in Kilburn, one assault for another. By substituting assaults here, the scope and purpose of the venture was changed, and there was an additional fact that the jurors had to determine. If there are no further questions, I see that my time.
Thank you, Mr. Doyle. Ms. Celia?
Good morning, Your Honors. May it please the Court, Kathleen Celio on behalf of the Commonwealth. Single justice denied the defendant's petition under 33E, and the statute precludes this court from reviewing it.
What about 211.3?
The defendant didn't, that wasn't the mechanism for the defendant presenting this. It was a motion for new trial. He filed the 33E petition. It is before this court on review of that petition. The statute precludes this court from reviewing it.
Why don't you tell us why this wasn't a horrible mistake?
It wasn't a horrible mistake because this court exactly decided it, and it's under 33E. I mean, this was the issue that the court decided under 30.
But didn't it really decide there was sufficient evidence of these other assaults?
No, there was no substantial likelihood of a miscarriage of justice from the fact that the jury wasn't, there was no difference in the jury instruction of the underlying felony of the armed assault, because there was two, this court held there was sufficient evidence of 2 armed assaults inside the house. It was encompassed in the Commonwealth's case, and it found that by not particularizing which assault was the underlying felony for the felony murder did not create a substantial likelihood of a miscarriage of justice. That was the exact issue.
Just answer this, if you can, Ms. Celia. The defendant is essentially claiming there was a joint venture to go and harm and possibly kill people who had been involved in the drug deals.
Correct.
Someone gets killed.
Correct.
Who was clearly not involved in that.
Correct.
And essentially the defendant's position is, whatever joint venture I was part of, I wasn't part of randomly killing people in anger who had nothing to do with the drug deal. And we know that one of the other co-venturers was upset when Barry, I think is the victim, was killed.
I mean, there was a woman that was pretty much forced to go in there to try to identify who was the drug dealers. There were no drug dealers inside. So and this court found that one of the issues before this court on direct appeal was whether or not the defendant had a specific intent for the assault, that he intended for them to be assaulted. And he said, and this court found that he did, based on the fact that he was heavily involved in the drugs, and that he didn't. So there was numerous in this court's opinion on page, I think it's 265. It was the third issue, I think, that the court decided. And so they said that he had the intent to go in there and to assault and to assault any of them, and that a killing came out of that assault. And that this court found that there was 2 assaults. So it wasn't like he had specific assault for one of them and not for the other one. He all intended for them to get assaulted or to go in there, and that a killing occurred from that, and that's how he was then convicted as a joint venture under the felony murder. And I think that this case is exactly on point with Commonwealth versus Kilburn, because it's factually just and procedurally just the same. I mean, it would be like if the single justice allowed it in this case and was before the court, it was pretty much dispositive. The same defense that the defendant had both in Kilburn and in Gunter, and that there was 2 separate assaults. The defense was both defendants made statements saying, I knew I was driving him over there, but I didn't want anyone to get hurt. I mean, that was both defenses, and that there was 2 specific assaults going on. And that Barry, who was the ultimate murder victim, was also the victim of the first assault, because the testimony was that all 4 occupants of the house were, by gunpoint, kind of pushed into the kitchen, and then they went to go look up for people, and then as they were going out, Barry was then assaulted, and as a result was shot. So I think that just based on Kilburn and the fact that I think under 33E, this court is precluded from review of this case, the defendant should actually dismiss the defendant's appeal and say that, I guess, the single justice denial of his request was proper. Thank you.
Thank you, Ms. Celia.